Hello all. As Brittany said, my name is Heather Tenney, and I'm a partner here at Tully Rinckey in the Federal Employment, Military, and Security Clearance Practice Groups. Today's consultation, as Brittany said, is about not so much the substance of different federal employment matters, although we will touch on a few about process and procedure, but it's really about what to expect and how to prepare best for a consultation involving a federal employment matter. So let's click through the slides and get started. There's me. We can click through that one. So what is it that we're going to do today? Well, we're going to start off by talking a little bit about what is a legal consultation. We're going to talk about the timelines of when you should probably consult with an attorney for a consultation and potentially even retaining an attorney for your legal matter. Then we're going to talk about how to be prepared for when you're going to speak with the attorney for the first time. Then obviously we'll talk a little bit about what happens after your consultation. And as I said earlier, we'll do a little bit of an overview of some specific and common federal employment matters that Tully Rinckey could assist you with. So what is a legal consultation? At its core, at its most basic, it's a conversation between you and a professional. Doesn't mean it's a chat necessarily, although it doesn't have to be, scary, but what it is allowing you to speak with an attorney to understand what your particular legal concern is and allow that attorney to advise you on what your potential options are. That also can include obviously strategy, can even include explaining what that legal process may be. Here at Tully Rinckey, we actually have a dedicated client relations department that's able to schedule a consultation with you and with one of our firm's attorneys for up to an hour. And because we have so many attorneys here at Tully Rinckey, that often means that we can, even when you might have a very quick deadline, even be able to arrange same-day consultations, although not always. So it's always important that as soon as you get something that or have some issue that may have some timely deadline, that you try and reach out as soon as possible to schedule a consultation so that deadlines don't pass. So what happens during a consultation? Well, like I said, at its most basic, it's a conversation. So most consultations, at least the ones that I conduct, we always start off with sort of discussing what the background is. What are the facts? Why are you calling? What's happened? And then obviously throughout the consultation, what you and the attorney can discuss are some of the defenses or strategy that may exist in the case. Obviously, if there are documents relevant to the case, reviewing those documents together during the consultation. As I said, discussing potential strategy that can occur with regards to your legal matter. Now, many of the processes in federal employment have a specific forum. They have a specific process associated with them. So many times, a lot of the discussion during a consultation is discussing that process, discussing the steps that will take place throughout the life cycle of the case, and as well as possibly some outcomes that could occur. And that can include reviewing strengths and weaknesses that may exist in your case. And then a consultation is not an agreement that you're moving forward with counsel at that time. The consultation itself can be all that you need, that you're having a discussion and you can receive legal advice regardless of whether or not you ultimately decide to retain the firm. Now, obviously, if there are things that occur during the consultation that ultimately you and the attorney believe would warrant representation moving forward, what can happen after the legal consultation is that we can then have our client relations team send you a written retainer agreement, which is a contract that ultimately would lay out what the attorney would then and the firm would then be doing moving forward on your case. And once you have that retainer agreement signed in place and payment has been made per the terms of that agreement, then your case is opened and it's assigned to one of our experienced attorneys within the Federal Labor and Employment Practice Group. Now, many times the attorney you speak to on a consultation is not necessarily the person who's ultimately going to be representing you. Like particularly like when I do consultations, I'm often not the person who then represents you because I spend most of my day doing consultations. So frankly, there's not enough hours in the day to then obviously be the person who's actually representing the client. In part, obviously, what the attorney who's doing the consultation though is doing is it's not like that's, you know, that none of that information that got addressed in the consultation then carries forward. In fact, when I'm finished with a consultation, number one, I've taken notes throughout, but then if that person then subsequently retains the firm, I then discuss what I had discussed with that client with their assigned counsel, provide notes, discuss what strategy we identified so that that information that is conveyed and then that can be used as the case moves forward. So in terms of timing, people will often say, well, when is it that I need to talk to an attorney? Well, frankly, as soon as possible. If you identify a potential problem or you have a particular process, or of course, if you have something that requires some type of response or has a deadline associated with it, you certainly want to reach out as soon as possible. Even if it isn't a situation where there's something specific that is due or a deadline, often it is best to talk to an attorney as soon as possible so you can identify what types of remedies that you may have and if there are deadlines, because there are many times in cases involving particularly like discrimination where there are some very restrictive rules that exist in the federal government for when you need to then present that claim, to file your claim. And if you miss those deadlines, it doesn't matter how egregious the matter is, then you may very well not be able to pursue that matter merely because you missed the deadline. So when you believe that some type of discriminatory event has occurred, or you face something that has a notice that they're taking some type of action, it's best to consult as soon as possible so you can know what your rights, what your options are. Also, too, you have to recognize mistakes can happen in this process. So even though you may know, for example, and we're going to talk a little bit about the details regarding particularly EEO, which is the process by which you assert discrimination complaints. Even though many of you may know that the deadline is 45 days, usually not a great idea to wait until the 45th day to file that complaint because mistakes can happen. It's always best to try and do something as timely as possible to ensure that if a mistake happened, that now you're not having to fight about whether or not that mistake should be ultimately waived and that the life of your case depending on that fact. So as early as possible, even if ultimately the conclusion of that is maybe it is too early, there isn't anything to be done, at least you've now been advised of that and you can be confident that you're not then potentially harming your future case because you didn't do something early enough. So as I've been saying, there are some very common areas in federal employment that we tend to do a lot of consultations about and also represent clients during. The first of which is federal employment EEO. And EEO is generally, you're addressing those things that are potential either acts or behavior that you believe are motivated by race, national origin, color, sex, disability, age, religion, genetic information, or retaliation for engaging in EEO activity. Every EEO complaint starts off as an informal complaint. And as we were talking about, you need to file an informal complaint within 45 days of the incident. Sometimes that's a little murky as to what the incident is. If it's a pattern of behavior, if there have been many instances, then you certainly want to make sure you're filing within 45 days of something that ultimately is the discrimination that you believe you have faced. Now, obviously, like I said, I listed, age, national origin, color, race, disability, religion, retaliation for engaging in EEO activity. Why I did that is EEO is not a catch-all. Some people think I'm filing an EEO complaint because I've been wrong, but unless your wrong is motivated by those things, then it's maybe not an EEO complaint. That doesn't mean you shouldn't have a discussion with a lawyer because it could fit into a different category or be a different process. But again, with EEO specifically, obviously you need to make sure that you're meeting those timelines, and that's a good idea to talk to attorneys when you find that you're suffering some sort of harm or prejudice or something's happened that you believe is motivated by those different protected bases that I've listed. During the informal process, you're usually either going to participate in what they call traditional counseling or alternative dispute resolution, which is more commonly known as mediation. During mediation, there's the opportunity for the parties to actually sit down and try and resolve it, negotiate a resolution. Traditional counseling is usually where the EEO counselor who is assigned sort of plays a game of telephone between you and the management officials at your agency to try and work something out. A lot of times it doesn't usually produce a resolution because you're not having the opportunity to really communicate your issues directly. But obviously that is a possibility of going through that traditional counseling process. But regardless, if the matter doesn't resolve during the informal, whether that's through traditional counseling or mediation, you will then receive what they call a notice of right to file a formal complaint. And with the formal complaint, you then have 15 days from the time you receive that notice to then file the formal complaint. And that 15 days is usually a hard and fast 15 days. If you miss that deadline, you are in significant jeopardy of your case therefore being dismissed. So always very important. If you did not have counsel and you now have received that notice of right to file formal and you want to get counsel, you should obviously consult very quickly because you want to make sure you're not missing those deadlines and you want to give that attorney the opportunity to advise you and potentially represent you moving forward. If other things happen since your original filing, you can add those things to your now formal filing. Then once that file is complete, the agency will then review it and they will accept what claims they're accepting for purposes of investigation. And then an investigator is assigned and the case moves forward with your interview, management officials interview. Ultimately, they're preparing a report. They have 180 days to do that. And if the matter doesn't resolve during that period, you're going to receive a copy of that report. When you get that they call the ROI, the report of investigation, you're then going to have 30 days from that date to make your choice on whether or not you want the agency to decide if discrimination or retaliation has been substantiated. That they call that a FAD, a final agency determination, or you're going to then choose to go to the EEOC and an administrative judge would be assigned and the case processes through that. But you have to make that election. If you don't choose, then they will just give you the final agency determination. So that's something another time when it's a good idea to talk to counsel so you can discuss your rights, discuss the pros and cons of the final agency determination versus going forward with the hearing, and then obviously potentially having representation for that. Now, obviously, if you've gotten all the way to the hearing process, then the hearing process can be very complicated. It's not usually something that people can handle on their own. It's not now about just telling your story. You're going to have to be in a position where you can offer evidence that's ultimately going to persuade a judge. And during the EEOC hearing process, there can be what they call discovery, which you have to make motions for and requests, and the agency is going to do that. All those things are things that attorneys can help you with. They're also all things that have deadlines associated with them. So yet another time that it can be beneficial. And if you're doing a consultation when you're in this process, it's usually going to be very beneficial for you to send those orders with those dates so that the attorney can be well advised of what status your case is in and what the next steps are and best advise you on, what the way ahead would be. And like I said, very strict deadlines with these things. And if you miss certain deadlines, that could ultimately be, very detrimental to the overall success of your case. Because if you can't get the evidence you need, you're the one who bears the burden of proof in an EEO case. So if you don't have the evidence, doesn't matter if it happened. If you can't prove that it happened, the judge isn't going to be able to find in your favor. Now, obviously, if the case has gone to hearing and there's a decision or there's been a decision on a motion for like what they call either summary judgment or a motion to dismiss that's been against you, so the case is now dismissed, you're then going to have the right to appeal that dismissal. And there's certain deadlines associated with that, either to go to what they call the OFO, the Office of Federal Operations, or ultimately to decide if you're going to opt out of the EEO process and go to federal court. And those are things that obviously you would want to timely talk to an attorney about so that you're aware of what those deadlines are. what the pros and cons of proceeding, what that process really is, and even then obviously have representation for those processes. Now, in terms of tips for EEO consultations, it is important, especially if we're talking about in the early phases, like you have not even filed your informal yet, to know specific dates. And why is that? Well, that's because you have to file these things within 45 days of an incident. So if you're very vague on the dates, it's going to be difficult for the attorney to be able to advise you as to whether or not you have a viable claim or not. So very important to make your notes beforehand to address timelines so that you can be prepared to talk to the attorney about the specific different discriminatory acts and when they happened. And doing that can often benefit you to put together a narrative, a description, a timeline, something. Now, that isn't to replace the conversation you have with an attorney. Some people like to send the narrative and figure like, okay, the attorney will just read the narrative and I don't have to say anything. Well, that's going to be a very boring consultation. Use the narrative to help you convey what you want to the attorney, but don't think of the narrative as a replacement for the conversation that you're going to have with your consult attorney. If you have any documents, like you have the notice of right to file your formal complaint, or you have orders from the administrative judge, you're going to want to send those. Even if they are voluminous, you're going to want to send them so that the attorney can review them with you during the consultation to make sure that we know what the deadlines are and make sure that we know that we're meeting those deadlines and that we also know what is required of that, because some things have very specific rules and how you respond, and you don't want to run afoul of the judge. And also, for us to be able to provide you the best advice, we want to make sure that we know what the left and right limit of those things are. And then, of course, for any consultation, you want to make sure that you're on time and you're ready to discuss the issues. Sometimes these things can be not the most happy experiences to talk about, but recognize the more open and candid you are with the attorney, the better the consultation will ultimately go and the more information that you can ultimately obtain. Another common area or topic that we often hear about and represent people for are disciplinary actions. That goes all the way from the start of a potential disciplinary action, which can be that somebody is under investigation for something, all the way to actually receiving a proposal for discipline, and even beyond when they've actually been disciplined. Now, in terms of investigations, when someone has either been contacted by, say, like an inspector general investigator, or just another member of the staff who's been appointed as an investigating officer, or even potentially law enforcement, although law enforcement is usually, there's a concern about what the actual nature of that would be, if that really is for employment purposes or for criminal purposes. But obviously all these things are things that, having a consultation would be warranted. Now, obviously, most of these things are going to involve an interview of you as a potential subject, but maybe just a witness. They're not really all that candid with you when they tell you there's an investigation. They often don't give you a whole lot of details. But talking to an attorney about what your rights and what your potential options are and whether or not representation would be a good idea and how that could benefit you is certainly something that can be done during a consultation. Now, obviously, another area is if that investigation is complete, or even if there wasn't an investigation, but now you've received a document saying we are proposing you for a discipline, whether that's a reprimand, a suspension, a demotion, and obviously, worst case scenario, a removal. Those types of things, they will lay out what the different charges are, or what the different accusations are, or what the different performance difficulties are, and why they're doing what they're doing. You then have the right to respond to those things, unless you're a probationary employee. That can have its own problems associated with it. But in any instance, it's a good idea to talk about this with an attorney. These things often have very, very tight deadlines, sometimes as little as 7 days to respond. So when you get something like that, it is not a good idea to, procrastinate. If you're looking to, even if it's just for advice, it's a good idea to reach out immediately to try and have a consultation so an attorney can sort of tell you what this process is, what types of things that you're ultimately going to be addressing, and obviously whether or not, representation would be beneficial, and if you're obviously going to have representation moving forward with that. Now, sometimes that doesn't happen, or even if you had representation, it does not resolve in your favor, and there's an appeals process, particularly when you're talking about things like removals, long-term suspensions, demotions of a pay grade. Those will often entitle you to appeals to even something like what they call the MSPB, the Merit Systems Protection Board. There's, again, very tight deadlines with regards to that. That ultimately can lead all the way to a hearing in front of an administrative judge. So those are things that you would ultimately want to reach out to counsel to discuss what your rights, your obligations, the process, the timelines are, so you can make sure that you're being compliant so you don't wind up losing any of your opportunities in that process. Now, for lesser forms of discipline, there's often things like administrative grievances, or you may be going the route of something like an EEO complaint, or like what they call an OSC complaint, which we'll talk about in a couple minutes. Those also have deadlines associated with it. So it's a good idea when you receive some sort of action like this to timely talk to an attorney so they can walk you through what your options are and what, the pros and cons of each are. And obviously, if you're going to move forward, then having counsel do those things for you so that you're, again, not losing out on any of your potential rights, obligations, best strategy, etc. So in terms of being successful for these types of consultations, always important, if you have the proposed disciplinary action, that you send that before the consultation so that it can be reviewed during the consultation. Because again, you want to make sure the attorney knows exactly what the different allegations are, the timeline, what your rights are, so you can actually walk through, not guessing about it, actually have those documents right in front, and they can give you the best advice when that's happening. Again, having a narrative to discuss what the underlying issues may be, the time frame, different potential defenses, always a good idea for you, but again, doesn't replace having the conversation with the attorney. It's more of a bit of a roadmap for you to make sure that you're getting out what you want and being able to convey that information to the attorney so you can get the best advice. Also start thinking about, and also maybe jotting down in your narrative for preparation, who would be potential witnesses? What types of evidence may you have that could potentially refute these things? Or not necessarily refute, even talk about like mitigation, what things may mitigate these instances and who could be, or what could be the evidence to help to support that, because that's going to obviously be appropriate for use in your reply. And then, like always, be on time and be ready to discuss the issues. Sometimes, particularly with disciplinary actions, there may be, some things that are said about you in there that are kind of embarrassing, but recognize, we as attorneys, we're not judging. We want to hear exactly what's out there, the good, the bad, and the ugly, because to pull punches, to try and minimize, doesn't ultimately do you any good, because then our advice is ultimately affected by the lack of information. So as I mentioned a couple minutes ago, the term OSC. The OSC is the Office of Special Counsel. Not every federal agency has the ability to file complaints with the Office of Special Counsel. In particular, usually postal employees can't go to the Office of Special Counsel, but there's actually quite a few agencies that can. But the ones that can, the OSC generally looks into what we call prohibited personnel practices. Probably the most common prohibited personnel practice that we discuss is reprisal for whistleblowing or protected activity. So that means if you've made some sort of complaint or appeal or grievance regarding violations of rules, regulations, gross mismanagement, gross waste of funds, abuse of authority, specific and substantial dangers to public health or safety, and as a result of those disclosures, you now believe that you have suffered a deprivation of a benefit of employment or an unfavorable personnel action, you may then file an action with the Office of Special Counsel saying that you're being retaliated against because of your disclosure. And the OSC can then investigate that. they can take corrective action, but even if they can't, they could ultimately give you the right to go to that Merit Systems Protection Board, the MSPB, in order to have the MSPB adjudicate whether or not the motivating factor and why that bad thing happened regarding your employment was because of your disclosure. Now, the OSC has much broader timelines for many things than the EEO, but still, if you're in that process where you believe something is motivated, it's best to talk about it with an attorney sooner rather than later. Number one, so that we can properly identify if that is the right tactic. Is going to the OSC right, or do you have some other right that may have a closer timeline, a more urgent deadline? But also, too, with the OSC, if you ultimately do go down that road and you then get a decision or a closure letter from them, there's only a certain time period for you to then file your appeal with the MSPB. So you want to make sure if you get anything from them, that you're reaching out to counsel to discuss that so that you don't miss any of your deadlines and therefore lose any of your rights and potential remedies. So in general, obviously, we talk about many different federal employment matters. However, some of the most common, other than the ones we've already talked about, generally we talk about a lot disability retirement, going through the FERS process through OPM. There are obviously specific criteria. It is actually an incredibly difficult process because OPM is very hypercritical of applications. So it is often a very good idea to reach out to counsel if you're looking towards applying, and even potentially having counsel represent you for doing your application, because unfortunately it's not always about, you know, whether or not you actually meet the criteria. It's whether or not you specifically state the things that need to be stated in the application to show that you meet the criteria. And OPM doesn't give you the benefit of the doubt in most instances. So you really have to be very clear, and having counsel can often help you direct that and make sure that you're being as clear as possible and have the things that you need. Also, for purposes of an application, if you are denied, you are then going to have the right to seek reconsideration of that denial. There's usually very firm time frames associated with that. You have to let them know within 30 days if you're seeking reconsideration. Thereafter, if they deny you again, you then have the right to go to the MSPB to appeal that. That also has very restrictive time frames. So you want to make sure if any of these things happen, you're talking to counsel, you're providing that documentation to counsel so that counsel can then properly advise you, and obviously if you then decide to move forward, represent you, and have the time to do so. Briefly touched on grievances before. In some types of disciplinary actions or other issues that are going on within, you may have the ability to grieve, which is an internal process. There is also negotiated grievance procedures, but that's often handled by your union, because those are things where there's a collective bargaining agreement or master agreement that lays out what the rules and process are. But in terms of administrative grievances, there can be very firm timelines. Usually for an informal grievance, you're usually going to have to assert that within 15 days of whatever the incident is. Probably the most common type of thing you're talking about here is something like a poor evaluation, or an evaluation that you disagree with, or a letter of reprimand is a common thing that's grieved because you don't have the ability to go to the MSPB. So those are things you're going to want to talk to an attorney about very promptly, so you can make sure that if you do want to take those steps, that you're doing so timely. Desk audits are another area that we talk about a lot. That's also commonly known as reclassification. That's where you believe that you're working in a position, but you're not being properly compensated, or that your title and your job duties are not properly reflected. There's different options for how to pursue that. Now, if you are a member of a union, you may have to go through them first, but if you're not, then ultimately that's a good idea to talk to counsel about, because there are different pros and cons to how you approach that, whether or not you're going to go through your agency, whether you're going to go through OPM, what you're going to present, and what the timelines associated with that are. So certainly something that we talk a lot about. Another big area, debts. So sometimes as a result of no fault of your own, you may have received an overpayment, or you may have been given something that they're now saying they're taking back. Well, there's a process and procedure in which to challenge those things. There can be a challenge where you're actually challenging the merit of whether or not that you actually owe the debt, but then there's also a process by which that even if technically you owe it, you may be seeking to waive it. And that's a process by which, we frequently advise people. Very good idea though here, if you get notification that they're trying to collect a debt, that you make sure you talk to counsel as soon as possible, because you have often the ability to stay the collection of that debt if you file your request within 30 days. But if you wait thereafter, they're going to continue to collect the debt. And sometimes the process by which you seek to correct this can take a long time. So during all that whole time, you're getting money taken out of your account. So in that instance, good idea if you reach out as soon as possible so that you can have the opportunity to fight, but not have the money taken out of your account while you're fighting it. So what are some bad habits to avoid? Well, as we've sort of peppered some of these things in throughout, obviously you don't want to withhold information. Yes, we all know that these are often, not pleasant topics to talk about. They also might have some level of embarrassment associated with it. But like I said, remember, we're professionals. We're not judging. We want to hear the good, the bad, and the ugly, because that's what's going to ultimately dictate what our advice is. And if you hold information back, then we're not giving you the best information. You're not then making the best choices based on the advice we gave you, because it was uninformed in essence. And remember, even in the context of the consultation process, you have attorney-client privilege. So it's not like you share this information with the attorney and then they turn around and tell, the agency. We have an obligation to keep what we discuss. Unless you're telling me you're going to hurt somebody and kill them, I can't disclose that information. So it's in your interest to say those things that may not be the most pleasant things to say, to make sure you're getting the best advice, and so that we can develop the best strategy moving forward. Also, too, we've talked a lot about documents. Now, there are specific documents, even though they might be voluminous, that the attorney is going to want. The attorney may even, when you book a consultation, you may get a message back saying, hey, please send this. And you might be like, oh, but it's 100 pages. The attorney may ask for it. But in general, don't send hundreds of pages. Don't even really send dozens of pages, because obviously the attorney can't review all of that. And you want to make sure that you're getting the most that you can out of the consultation. Also, don't send things like chains of emails or a bunch of text messages. It's very difficult for an attorney to figure out what that means, because it requires a lot of context. Those are things that maybe once the representation, if you're going to retain counsel, are definitely going to be useful, but usually not during the consultation itself. And again, remember the things that I said, like some things you may think are, oh, I want the attorney to look at this, but remember what the attorney is often going to want to see is the official stuff. So if there's a proposal for removal, we're going to want to see the thing the agency gave you, not necessarily see only your response to what the agency gave you. That's fine if you send the draft, but you also want to send the actual proposal too, because we want to make sure that we understand what is the agency is accusing you of, what are the deadlines, what are the timelines. And obviously in preparing, when you're creating things, make sure that you're remembering, okay, what are the dates of these things? When are these things, when did I get this? When did I that? Because that's the stuff the attorney is going to want to know, because that dictates what the deadlines are, what the next steps are. Also remember, as much as obviously you're having a conversation with the attorney is there to give you legal advice. They're not there to be your cheerleader. They're not there to agree with you. That's not a particularly useful thing for you. So remember, it's important to listen to the attorney's perspective, even if you don't really like it, because what we're often doing is we're trying to show you what the other side is going to see and what your burdens are going to be, and what things you need to think about when you're pursuing these actions. Because at the end of the day, many of the things in the federal employment world, you're going to bear the burden of proof. It's going to be your job to establish it. And we're trying to point out what the potential pitfalls are. Doesn't mean we're trying to be mean. Doesn't mean that we're just trying to be disagreeable. We're trying to show you what you will have to overcome, and also try and get answers to that. If you have a response, great. But you have to listen to the attorney's perspective if you want to get the most out of a consultation, because we ultimately are trying to help you, and we want to make sure that you don't go down a road thinking that the process is one thing, then months or even sometimes years later realizing that's not what it was. Plus, as attorneys, we have ethical responsibilities. If you tell us something that we know is a potential problem, we have to tell you that's a potential problem. That wouldn't be a good idea it wouldn't be in the long term nice for you if an attorney tells you everything's great about your case, tells you to retain them, and then 2 days, 2 weeks, 2 months from then everything falls apart, and the attorney could have told you that at the very beginning, but they didn't because they wanted to spare your feelings. Okay. Well, this is our contact information. So ultimately, if you have something that fits into either of these categories or something else, and you believe that you would benefit from having a consultation, then that's certainly what you should do. Especially, again, obviously here we don't often do a lot of questions because they tend to be very personal type questions that I don't think are proper to share in that forum, but that's certainly what a consultation is for. So if you have any of the issues that are here or any issues that could be related to federal employment and you want ultimately legal advice, then these are some of the details. We also have on our website the ability to book consultations, and we would be happy to help you. A question came in about federal court, about costs, about percentage. A lot of that is going to be individualized. I mean, I don't know what the federal court action is going to be about, so I can't tell you what the cost, but I can tell you federal court actions are very costly. In terms of percentages, we generally don't do that form of representation where we take a percentage. We do retainers based on the work that's performed. Some law firms do either contingent representations or what they call split representations, where they will take a portion of the recovery that you receive. We don't do that. Getting into the issue of legal costs, depending on what your action is, you may be entitled to legal costs as part of your damages. In many EEO cases, legal costs are part of the damages. But with regards to certain types of EEO cases, usually involving age-based complaints and what they call equal pay claims, attorney's fees are not recoverable in the administrative process. Many other areas, if you get to certain levels, like at the MSPB, attorney's fees are recoverable damage, but not for every action are legal fees recoverable as a damage. Somebody asked about whether we have an attorney in Kansas City. We do not have an office in Kansas City. However, for many federal employment matters, it does not matter. It's only if the case is actually in federal court that we would need to have you would have to have representation who is licensed in that state. We represent people all around the globe. We have clients in Japan and Korea and Germany. We have clients all over the United States, particularly for like EEO, MSPB, the different proposals, the actual actions, because you don't have to be licensed in those jurisdictions. But obviously, if the case is in federal court or in state court, you're going to need counsel that's locally admitted. Somebody asked a question about signing a settlement agreement and whether or not they can file a report with No Fear Act. Generally, settlement agreements do not prevent you from being able to whistleblow. However, they would prevent you from being able to recover damages because of a whistleblower. So you can report. They can never restrict you from reporting what would ultimately be, a violation of rule or regulation, gross mismanagement, waste of funds, abuse of authority, or retaliation because of those things. But a settlement agreement can prevent you from being able to obtain damages because you suffered retaliation due to your disclosure. There's a question specifically about violations of a settlement agreement that was done by a union. Generally, it would not be a OSC complaint if they are claiming that a settlement agreement was not complied with, and the union won't take up your case. Then your probably best option is to go to what they call the National Labor Relations Board to complain not only about the violations, but also to complain about the union itself. But the OSC really wouldn't probably be the appropriate remedy. I mean, you can file anything with them, but they probably won't do anything about it. Your better option is to go to the National Labor Relations Board. But also recognize the reason behind why the union may not be pursuing it is that they don't actually believe it's a breach. So, because I talk to a lot of people who say that their settlement agreement has been breached, they give me the settlement agreement, we talk about it, and that's not a breach. Well, thank you all, and if you guys do have an individual legal issue and you need advice, please feel free to reach back out. We're always here to help. And happy holidays, everyone.